Welcome to presentation on the Environmental Protection Act 1986 by RAVI PRAKASH MATHUR, Senior Lecturer, Mechanical Engineering Department, Government Polytechnic College, Jodhpur. The objective of the act are as follows. The act to provide for protection and improvement of environment, prevention of hazards to human beings, other living creatures, plants and property, for prevention and control of environmental pollution, laying standards for quality of environment, restrictions of areas for location of industries, safeguards for handling hazardous substances, research relating to environmental pollution. The definition, important definition under the Act, first is environment, includes water, air and land and the interrelationship with which exists among the between water, air and land and human beings, other living creatures, plants, micro-organisms and property. Second definition is environmental pollutants means any solid, liquid or gaseous substance present in such concentration as may be or tend to be injurious to environment. Third definition, environmental pollution means the presence in the environment of any environmental pollutant. Fourth is the handling in relation to any substances means the manufacturing, processing, treatment, package, storage, transportation, use, collection, destruction, conversion, offering of sale, transfer or the like of such substances. Hazardous substances meaning any substance or preparation which by reason of its chemical or physiochemical properties or handling is liable to cause harm to human beings, other living creatures, plants, microorganisms, property or the environment. Occupier in relation to any factory or premises means a person who has control over the affairs of the factory or the premises and includes in relation to any substance the person in possession of the substance. Section 3. Power of central government to take measures to protect and improve environment. Number first, the central government shall have the power to take all such measures for the purpose of protecting and improving the quality of the environment and preventing, control and abating environmental pollution. The second category of object is the measure which may be related to following matters, namely, number 1, coordination of actions by the state governments, officers and authorities under this act or the rules made thereunder under any other law for the time being in force which is relatable to the objects of the act. Second, planning and execution of a nationwide program for the prevention, control and abatement of environmental pollution, laying down standards for the quality of improvement in its various aspects, laying down standards for emission of discharge of environmental pollutants from various sources whatsoever, restrictions of areas in which any industries, operations or processes or classes of industries, operations or processes shall not be carried out or shall be carried out subjected to certain safeguards. Laying down procedures and safeguards for the prevention of accidents which may cause environmental pollution and remedial measures for such accidents. Laying down procedures and safeguards for the handling of hazardous substances, examination of such manufacturing processes, materials and substances as are likely to cause environmental pollution. Next is carrying out and sponsoring investigations and research relating to problems of environmental pollution. Third, 10th, inspection of any premises, plant, equipment, machinery, manufacturing or other processes, materials or substances, and giving by order of such directions to such authorities, officers or person as may be considered necessary to take steps for the prevention, control and abatement of environmental pollution. Establishment or recognition of environmental laboratories and institutes to carry out the functions entrusted to such environmental laboratories and institutions under the Act. Collection and dissemination of information in respect of matters relating to environmental pollution as relating to the prevention, control and abatement of environmental pollution. Section 4 covers appointment of officers under the powers and functions. Powers and functions. Section 5, power to give directions. The central government may issue directions to in writing to any person, officer or any authority, and such person, officer or authority for the closure, prohibition or regulation of any industry, operation or process, or stoppage of regulation of the supply of electricity or water or any other service. Section 6, rules to regulate environmental pollution. The central government may make rules in respect of or any of the matters referred to in Section 7. Section 7, persons carrying on industry operations etc. not to allow emissions or discharge of environment pollution in excess of the standards. Section 8, the person handling hazardous substances to comply with procedural safeguards. Section 9, furnishing of information to authorities and agencies in certain cases where the discharge of any environmental pollutant in excess of the prescribed standards occurs due to any accident, the person responsible for such discharge and the person in charge of the place shall be bound to prevent or mitigate the environmental pollution caused as a result of such discharge and shall also forthwith intimate the fact of such occurrence and be bound, if called upon, to render all assistance. Secondly, on receipt of information, the authorities shall, as early as practicable, take remedial measures to prevent or mitigate the environmental pollution. 10. Section, powers of entry and inspection. Any person empowered by the central government shall have the right to enter at all reasonable times any place for the purpose of performing any functions of the central government entrusted to him, for the purpose of examining and testing any equipment, industrial plant, record, register, documents, or any other material object, or for conducting a search of any building in which an offence has been committed, and for seizing any such equipment, industrial plant, record, register, document, or other material object that it may furnish evidence of the commission of an offence, or that such seizure is necessary to prevent or mitigate environmental pollution. If any person willfully delays or obstructs any authorized person in the performance of his functions, he shall be guilty of an offence under this Act. Section 11. Power to take sample and procedure to be followed in connection therewith. The central government or any officer empowered shall have power to take for the purpose of analysis samples of air, water, soil or other substances from any factory, premises or other places in prescribed manner. The result of any analysis of a sample so taken shall not be admissible in evidence in any legal proceedings unless the provisions prescribed are complied with. The sample shall be sent for the analysis to the laboratories. Environmental laboratories. The central government may establish one or more environmental laboratories, recognize one or more laboratories or institute as environmental laboratories to carry out the function entrusted to the environmental laboratory under this Act. The central government may make rules specifying the functions of environmental laboratories, the procedure for the submission to said laboratories of samples, and any other matter necessary. 13th Section, Government Analysts. The central government may appoint or recognize persons having the prescribed qualification to be government analysts for the purpose of analysis of sample. Section 14, Reports of Government Analysts. Any document purporting to be a report signed by a government analyst may be used as evidence of the facts stated therein any proceedings under this Act. Section 15. Penalty of contravention of the provisions of the Act and the rules, orders and directions. Whoever contravenes any of the provisions of this Act shall be punishable with the imprisonment of a term which may extend to 5 years, or with the fine which may extend to 1 lakh rupees, or with both. And in case the failure or contravention continues, additional fine may be imposed. Secondly, if the contravention continues beyond a period of 1 year after date of conviction, the offender shall be punishable with imprisonment of a term which may extend to 7 years. Section 16. Offences by companies. Where any offence under this Act has been committed by a company, every person who at the time of offence was committed was directly in charge, as well as the company, shall be deemed to be guilty of the offence and shall be liable to be proceeding against and punished accordingly. Section 17. Offences by government departments. Where an offence under the Act has been committed by the Department of Government, the head of the department shall be deemed to be the guilty of the offence and shall be liable to be proceeded against and punished accordingly. Section 18. Protection of action taken in good faith. No suit or other legal proceedings shall lie against the government or any officer or other employee of any authority constituted under this Act in respect of anything which is done or intended to be done in good faith in pursuance of this Act. Section 19. Cognizance of offences. No court shall take cognizance of any offence under this Act except on a complaint made by the central government or any authority or officer authorized in this behalf of the government, or any person who has given notice of not less than 60 days in the manner prescribed of the alleged offence and of his intention to make a complaint to the central government or the authority or officer authorized as prescribed. Section 20. Information, reports or return. The central government may, in relation to its function under this Act, from time to time require any person, officer, state government or other authority to furnish to it or any prescribed authority or office or any reports, returns, statistics, accounts and other information. Section 21. Members, officers and employees of the authority constituted under Section 3 to be public servants as required in Indian Penal Code. Section 22. Bar for jurisdiction. No civil court shall have the jurisdiction to entertain any suit or proceedings in respect of anything done, action taken or order of direction issued by the central government or any other authority or officer in pursuance of any power conferred by the relation to its or his function under the Act. Section 23. Power to delegate, and Section 24. Effect of other laws subjected to the provisions of subsection 2. The provisions of this Act and the rules or other made therein shall have effect notwithstanding anything inconsistent therewith contained in any enactment other than this Act. Second clause. Where any act of or omission constitute an offence punishable under this Act and also under any other Act, then the offenders found guilty of such offence shall be liable to be punished under the other Act and not under this Act. Section 25. Power to make rules. The central government may, by notification in the official gazette, make rules for carrying out the purpose of this Act. Such rules may provide for all or any of the following matters, namely the standards in excess of which environmental pollutants shall not be discharged or emitted under Section 7, the procedure in accordance with the safeguard in compliance with which hazardous substances shall be handled or caused to be handled under Section 8, the authorities or agencies to which intimation of the fact of occurrence of the discharge of any environmental pollutant in excess of the prescribed standard shall be given, and to whom all assistance shall be bound to be rendered. Next, the manner in which samples of air, water, soil or other substances for the purpose of analysis shall be taken. Next, the form in which notice of intention to have a sample analyzed shall be served under. Next, the function of the environmental laboratories, the procedure for the submission to such laboratories of samples for analysis or test, the form of laboratory report, the fees with respect to subsection 2 of the section 12. The qualification of government analysts appointed or recognized for the purpose of analysis of samples, the manner in which notice of the offence and of the intention to make a complaint to the central government shall be given under clause B of section 19. The authority or officer to whom any reports, returns, statistics, accounts and other information shall be furnished under section 20. And lastly, any other matter which is prescribed. Section 26. Rules made under this Act to be laid before Parliament. This is the fact that the two sections of Parliament, this namely Lok Sabha and Rajya Sabha, this proposal of this rule should be put up, and if they allow it, it may be implemented, or if they suggest modification, the modification may accordingly be made. Thank you.